Good afternoon, everyone. Welcome to Medicaid Monday. Frank and I are happy to be here and happy to be presenting these sessions each month on the second Monday of the month. And they have taken a course over the last 2 years trying to cover every hot issue in Medicaid, and we'll talk to you at the end about what's upcoming. This is our law firm. We have a couple additions that will be going up on this chart soon. But we practice primarily in the upstate Albany area. We go up to the Canadian border, to Plattsburgh. We go west, probably no further than Utica, although we can go, if necessary, further west. But south, we go all through the Hudson Valley, down into the 5 boroughs. Manhattan is our office downstate. We go to Long Island, Nassau, Suffolk counties. We have a Garden City office, and we service that geography. Our firm is limited to estate planning, elder law, special needs planning. We have a concentration in Medicaid planning, hence Medicaid Mondays. And we're very happy to be here with Frank and myself to try to get you up to date. And Frank, what are we going to talk about?
So we're going to do a quick recap of the numbers. We do have one quick addition that we weren't able to share last time just because information kind of went live just as we were going live for January. And then we're going to talk about single people and kind of what planning challenges they face, what some options they have, and just some conversations that they probably need to think about.
And being solo later in life presents unique challenges. So we fashioned today's presentation to address them. There are groups actually out on social media that are coalescing where people don't have children as their agents. They don't have the ability to integrate family into their plan. So what do you do when you're in that situation? We're going to talk about that during this half hour. We think it's important enough to warrant a session all by itself. Before we get to that, the numbers are always important. And Frank, we have some changes, but some non-changes.
I was going to say, we have a lot more not changes more than anything. It's so as of like right now, last time I looked, they hadn't updated the new numbers for 2025 yet based on the federal poverty numbers. So for now, we're still going to use mostly the numbers from last year. So 1752 for income for a single person. For if it's a couple, it's 2371. You got your community spouse allowance. So if you're the spouse and your spouse is on Medicaid, right? If you're the well spouse, then you get almost $4,000 a month of income. That's the one that went up to $39.48. And we still have $50 of your income allowance for the nursing home. That hasn't changed. We didn't anticipate that to change, and it didn't change. So that's the numbers for income. And then for assets, again, mainly unchanged, 31,175 for a single person. For a couple where they're both on Medicaid, it's 42,312. And again, the lower tail of the community spouse resource allowance so far did not change. So that's still 74,820. Upper tail did go slightly up to 157,920, but we don't usually spend a lot of time with that. So on we go. And then this is the new information that we were not able to share last time. So they did release the new regional rates for 2025. So these numbers are important if you're calculating a penalty period. So if you have a chronic care situation where you're looking at a nursing home and gifts or transfers made in the 5-year period, these would be your new divisors to figure out penalties. So as anticipated, all the regions did go up. I think of note, and I didn't really realize this until I looked at it a little closer, Rochester now has, or the Rochester region has the highest number now, even higher than New York City or Long Island. It looks like that has steadily gone up over time. Now it is the highest single number, but all the regions did go up. So if you do this kind of work or you're trying to anticipate what a penalty would look like, these are the new numbers to use for that. And essentially the good news here is because they all went up is you can give slightly more money away or transfer slightly more money to still only have a 1-month penalty. So it did kind of go in a positive direction, but not a big change, but that wasn't anticipated.
So I don't want to take too much time away from our solo seniors presentation, but where do these numbers really come into play in nursing home cases today? We have a home care program coming up. We'll talk about that next month. We're looking at what is the status of the look back period. As you probably know by now, we've talked about it for the last 4 years. The state imposed a 2.5-year look back. What is a look back? It's the time period within which the government and Medicaid look at asset transfers. Within that time period, they then assess a penalty. So there are 2 different time periods, 2.5 years for home care, 5 years for nursing home care. Once they ascertain, Frank, that there are transfers, there is a calculation that you have to do to determine the months of ineligibility.
Correct. So you would take the number of, or you take the total amount of money that was gifted or transferred away in that period. So 2.5 for home care, potentially 5 years for a nursing home, total up all that money. And then you divide it by the penalty number, which is the divisor for whichever region that you're looking at here. So in the Albany area, we typically were using that 13,235 number last year, 13,916 this year. But again, it all depends on kind of where you're located or where the facility is located, where you're doing this kind of work.
And how do we anticipate these numbers to change over time? New York is one of the more generous states. When you go to the asset limitation of 31,175, most states allow you to keep $2,000 of assets, which is the SSI threshold. So New York went up over time to 31,175. When you gift assets, you have a 5-year look back, you have the penalty period, the divisors, as you see here, and these are not private pay nursing home rates. These are 120% of the Medicaid reimbursement rate. So as you probably know, Medicaid does not pay nursing homes the same amount as private pay. So they use those numbers, the Medicaid numbers, rather than going and polling every nursing home to find out what the true private pay rates are. And that's the divisor that we're using. And Frank, generally the rates for nursing homes private pay are 10, 20, 30% higher than these regional rates.
Oh yeah, I mean, just to use the capital district as kind of the barometer, just because we see those numbers by far the most. You know, any facility in this area where our office is going to be between 15 to 17,000 a month private pay, if not maybe even a little higher now that we're into 2025 because of cost of living adjustments and other things like that. So
Yeah.
The penalty number is 13,916. Actual is probably between 15 to 17, maybe even 18,000.
I'm seeing clients coming in with $18,000 a month bills.
Yeah.
And that's where we're at. Probably 16 to 18 now, we can ratchet up the bracket. And these numbers are not going to get better. Right now, the state had a little bit of a surplus. And so tax revenues were up for 2024, and that's the good news. And the budget did not get cut as steeply as it was projected to be cut. However, in the federal government, I just got our NALA alert. NALA is the National Academy of Elder Law Attorneys, and they are projecting at least a $2 trillion cut in current government spending on issues like Medicaid. And President Trump has said he's not going to touch Medicare and Social Security. So Medicaid is a program that is on the chopping block. And that could be block grants, that could be other forms of cuts. So as those cuts trickle down to the state, these numbers may well change, not in a positive way, but in a negative way. And in fact, representatives from Elon Musk's Department of Government Efficiency were at the Centers for Medicare and Medicaid Services this week. This is that last week, to take a closer look at the programs. So we'll see what shakes out of Washington. It seems to be a day-to-day watch to see what new executive orders are coming out, but we will be following that and trying to track it through to see how it affects us right here in New York State. And with that, Frank, let's jump into our topic du jour, which is how do we deal with all of these issues for people that are not in a family, don't have a spouse, and are looking at planning and creating a plan for themselves to achieve their goals and secure their futures.
It can be difficult, especially if there's not, I think, some groundwork done by the client in our case, because typically speaking, when we talk to families about their plans, a lot of times all the roles that need to be filled, whether it's your power of attorney, your healthcare proxy, your executor, your beneficiaries, whomever we're talking about, normally that's going to be either your spouse or your children. And in this case, we're typically dealing with people that either don't have a spouse, don't have children, don't have both. So I think a lot of the times it comes down to who are the people that you have in your life. And ultimately, the other question that I think people struggle with more than anything else is, well, what do you want to have happen, and what does your future look like? What would make you happy? You know, how do you want this to go?
So being a solo senior can happen in a number of different ways. And a lot of people just never married, don't have kids. And now as they age, they're looking at securing their own future. And what does that entail? So as estate planners, we're going to look at the documents that we have available to us and the programs that we have available to our clients that can allow them to avail themselves of the best in all of the categories and filling voids that are otherwise daunting.
Yeah. So like we're trying to just kind of come up with some ideas of how to kind of illustrate these points. So one avenue that we thought would be helpful would be to kind of illustrate how someone can become a solo senior. So sometimes that happens because of a divorce, where someone was married and then the marriage falls apart, and now someone who had a spouse no longer does. So if this is speaking to either you or somebody that you know, or somebody that you may want to recommend to talk to people like us, right? When you're divorced, one of the biggest things you want to look at is revising any documents that you have or revising the plan that you have. So if you have a will, if you have a trust, if you have your ancillary documents, you clearly want to get those looked at and updated, because chances are, if you had a spouse, they're probably sitting in some pretty important positions that you probably no longer need to be sitting in. The other big thing is want to make sure that your beneficiary documents, whether that's your will, your trust, or even your beneficiary designations, are now up to date with your new change in circumstance. Again, we wouldn't want typically things going to an ex-spouse. I suppose sometimes people may, but most of the time they don't. So you want to make sure that nothing's going to funnel to them, whether it's through your documents or your other decisions. And the last point, and this is going to kind of be a recurring theme, is it might be a good time to create that plan, whether it's a Medicaid protection plan, whether it's just a probate avoidance plan, could even be just a will plan for some people, depending on what your assets are and what you're bringing to the table. But you want to make sure that you create that new plan, get it funded, get your stuff updated, and make sure that you start taking steps to make sure things are going to go as you want when the time comes.
So the first step in the process is taking an inventory. And that's a personal inventory and a financial inventory. So when we do our estate planning, we send our clients a link to a program called Decision Vault. And in that, it's going to ask them for who are the key people that they're going to consider to be appointed in various roles. What are the assets that they have to secure themselves, to provide themselves with income, financial security? All of the facts need to be put in place before we can really go forward and look at diagramming the plan for them. But it's some common themes and some common threads that over time, and I've been doing it 40 years now, Frank, 10.
Yeah, a little less.
But common themes that have just arisen over that time. And how do you put in place that plan that secures you financially, secures you your healthcare, and make sure that you have a smooth transition? So who are the people that you would trust to make healthcare decisions, financial decisions? How do you find those people? How do you bring those people to the table? What documents bring them in? How do you then look at your assets to make sure that you have enough control and access to make sure that you have the ability to use them for yourself throughout your lifetime? And Frank, the trusts are even more important than they are for anyone who is a married couple or anyone who has children and other people that they're trusting and allowing to do things for them. Because in a trust, we can put in place legal relationships, trustees who are fiduciaries, who can look after trust assets, look after things when you can no longer look after them for yourself. So we're going to talk about the revocable trust, which a lot of solos choose because they stay in control, and the Medicaid Asset Protection Trust. And those are the two primary vehicles to plan for your future when you're looking at setting yourself up. And the big difference, Frank, is long-term care. And doesn't this couple look happy? That's a great graphic of the situation about to be a solo senior.
Yeah. The biggest change, just to kind of go off your point, Lou, or one of the biggest differences with a revocable trust, you're typically in charge of everything until you can't be, right? The purpose of that trust is to create a plan to avoid probate when you pass away, make sure your beneficiaries inherit as you want, and try to make things kind of nice and easy in a holding tank that someone can step in and manage things for you if something were to happen. Conversely speaking, a Medicaid Asset Protection Trust is a type of irrevocable trust where you give up some control, right? We have to select a trustee other than yourself that can manage things on your behalf. And again, the biggest thing that's driving some of these decisions are whether you want to protect your assets or not. When we have single people, I've had plenty that say, I've worked really hard for everything that I have that I would put into a trust. I want to make sure those never go to the government, to the nursing home, whatever. And it can go to my siblings, it can go to my nieces, nephews, and go to charities, whatever it is that they want. They want to make sure that their hard work benefits someone or some entity. Other people say, it's my money. I don't care if I use every dime for me, whatever goes to whomever I want. that's gravy for them, right? They shouldn't expect anything from me. If I die penniless, whatever, I used all my money on me and I'm okay with that. So that's why this is sometimes a complicated area per se, because lots of people have lots of different feelings about this. And at the end of the day, you should be doing what feels most comfortable to you. So sometimes we have people, right? They start out married, but then their spouse passes away. So now they're a solo because they lost their spouse. So again, some things to consider would be to revise your current documents. But there are also some financial, I think, things that maybe come into play a little differently here that people don't always think of. So for one, you might have reduced income, right? You might be used to having a 2-income household where now you're a single income household. And you also, depending on what that looks like, you may also have to take an account for being able to survive on only one income, or knowing that you're going to start having to dip into your assets to provide for your lifestyle or your care as you get older. And then again, if you've lost someone, now that would, if you hadn't done any previous planning, that would certainly be a time to start considering things about how you want now things to go if you're by yourself and what you want to have happen when your time comes.
A fundamental difference between a trust and a will plan is that the will does not have any impact or authority until you are deceased and someone, your appointed executor, takes that will, prepares all the petitions, paperwork, affidavits, files it with the court, and gets back a certificate of letters testamentary. That has no impact during your lifetime. The will does not speak at all during your lifetime, and it doesn't speak upon your death until someone clears the probate hurdles. And this requires, if you are a solo senior, the executor to find all of your next of kin, all of your distributees, the people who would take if you had no will. And that is a job that sometimes is very, very daunting. And a lot of people don't consider the fact that they might have to find your relatives, in Croatia, all over the world, to get them served with process just to probate your will. One of the features of a living trust is it can avoid probate, and it can be done on a very expeditious basis for your beneficiaries. More importantly, trusts give you advantages during lifetime, and these are often overlooked by people. So during lifetime, a revocable living trust would have your assets and they would be titled in the name of the trust, and you would be the trustee. If at some point in the future you're determined not to be able to be the trustee, and that's typically a medical order or a court order, then your succession of trustees will occur and you will have someone step in to be your fiduciary under a trust agreement where you have set out specific instructions that the trustee follows to manage your assets and use them for you during your lifetime. And then the critical question is what? Who would be that trustee? The alternative is a power of attorney. And I can tell you that trust companies will not act as power of attorney, but they will act as successor trustee. So we very often at this stage look to who is the next trustee in line, who is going to take care of my assets and me in the event that I can no longer do it for myself. And very often that's either a professional, an accountant or attorney that you have a relationship with, or it's a professional trustee, which is in the form of a trust company. We happen to be doing a program tomorrow called our Trust Administration Workshop, which we do quarterly. It's here in Albany, and we do it in conjunction with Trustco Bank. And Trustco is one of the local institutions that will work on both revocable and Medicaid asset protection trusts. So we're going to talk a little bit more about that selection process when we get to that.
Yeah, so another kind of group of people in this solo single senior scenario could be people that just were never married. They've been solo their whole life. So I think these people tend to have to spend a little bit more time usually thinking about who their agents would be for their power of attorney, for their healthcare proxy, for their disposition of remains to make sure that their wishes are carried out. And then secondly, again, determining who those beneficiaries are going to be, right? Because the easy spots of spouse, children, or grandchildren, more remote descendants, right? They typically aren't here. So this could be it could be other family members, it could be friends, it could be charities, it could be a mixture of all of those things. It's just a matter of what do they want to have happen when the time comes. And then once they've figured out who their agents are going to be, who their beneficiaries are going to be, then it's either create the plan or amend the plan, whether that's with a will, with a trust, again, depending on what assets they're bringing in. But as Lewis said quite eloquently, is if you're kind of a solo person and you're trying to uncomplicate things as much as possible, a trust will certainly allow you to do that much easier than a will. Another thing to just keep in mind would be to prepay possibly your burial. Again, just to kind of take needed steps off the table for either your successor agents or that professional trust company, if you go that route, to have to take with or to deal with. And then you obviously, again, you want to update your beneficiary designations or fund your trust, depending on what avenue you took with creating that plan, whether it's a trust plan or a will plan.
So where do you want to live? These are fundamental questions that everyone has to face, but where do you want to live? And I have people in their own homes that say, if something happens to me, how do I survive here? Who's going to take care of me? So alternative living arrangements may be something you want to consider. Independent living, housing, apartments, wonderful communities locally. We just had our radio show Life Happens. We had the head of the Eddy independent living units, and they have wonderful independent living with all enriched services and people that you can associate with. That might be a choice that you want to consider more than just a married couple who is in their own home and still has resources available to them. If you are a solo, having that community and working in that community, living in that community is something that you may want to consider sooner rather than later, going along with the legal planning, the financial planning, security, and then what happens if you can no longer manage all of this for yourself. And I can tell you that one of the most emotional meetings that I have is with people who are solos who sit down, and when they start evaluating who's available to them to take care of them, I have to bring the Kleenex out because the tears start to flow. It's a very, very emotional issue. Getting it done early, getting it done with some systematization and an ability to put facts on the table and deal with it rationally, analyze it, and put a plan in place is the way to go.
Yeah, couldn't agree more. So again, it's coming down to identifying your goals, figuring out where you want to be, where you're best suited to be, what steps you can take to get there. Can you afford to pay your way through, or do you have to do some advanced planning to rely on programs like Medicare, Medicaid, or can you go possibly the insurance route? Do you have all your legal ducks in a row? Do you have all your financial ducks in a row? And more than anything, can I just put the team together around me? That way, when something happens, that I'm going to be supported in carrying out the wishes that I have.
And if you have a good financial advisor, that's a key person in your plan. A legal advisor who talks to the financial advisor and helps you to put the plan together. Your accountant who's going to manage all the tax aspects. That's your triumvirate of legal financial advisors that build a plan around you. And it's critical that you have them talk to each other, communicate with each other, and we try to do that as much as possible. And we have active programs for our clients to enhance that ability using common information and data and having that available. So the action plan may involve looking at insurance. Is Medicare the answer, Frank?
No. Because again, like this is Medicaid Monday, right? We title it that way because we mainly talk about Medicaid, and while we're kind of veering slightly off from our normal topic that we talk about, Medicaid still slots in here because for many people, Medicaid is going to be the government program that's going to take care of you as you age, unless you either take steps to make sure that you can either privately pay for those services if you need them, you get insurance to pay for them, or you plan on, if I ever need Medicaid, getting Medicaid in place without having to spend down all of my assets and resources and income. And that's why we do the series that we do.
So we just did our Life Happens radio show Saturday with Bob Vandy and Dave Kopic, financial advisor, insurance advisor, talking about long-term care. Long-term care insurance policies, there's one company other than mutual companies where you have to be an agent of that company to sell the policy. And that's Mutual of Omaha. We're down to one from what was once 15 or so companies in New York selling long-term care insurance. But there are excellent other types of insurance policies, hybrid policies, which combine some death benefit with some long-term care. And those are excellent alternatives on the financial side of long-term care planning. So building a team, making sure you have your income protected, making sure you have your assets protected, and these needs are going to change over time. I want to make one point. Healthcare proxies require an agent. So do you have someone who you trust, niece, nephew, friend, family member, that would make healthcare decisions for you if you can't make them for yourself? The other documents that become critical for solo seniors are the living will and potentially a MOLST form. So a living will is a document which embodies end-of-life decision-making. How do I want to be dealt with if I develop an illness that I can no longer communicate and it's going to be terminal? I don't want to be kept alive by artificial means. A living will is a standalone document that can accomplish that. The medical order for life-sustaining treatment, or MOLST, the pink form over on the right of your screen, is a document for solo seniors that is absolutely essential, because this is a document you do with your medical provider, doctor or PA, and it includes all of your wishes with regard to artificial respiration, hydration, nutrition, antibiotic treatment. Do you want at some point a DNR? All of those things are dealt with medically in a medical order that becomes part of your chart. So if you don't have that person that you trust as your healthcare agent, trust your doctor to make the right decisions with you through your MOLST form, and that document stays with you throughout your lifetime. Every time you go to the hospital, you go to the doctor, your wishes are known, they're enforceable, they are in a medical order. So for solo seniors, MOLST is something that is extremely valuable. On the power of attorney side, Frank, it's a lot harder.
Yeah, because I think there's just different things that have to be put into perspective. So one is, again, who your people are going to be. So this, you can appoint co-agents if you have multiple people. If you want to keep it one at a time, you can, but always make sure that you have probably several layers of alternates just in case. Just to put it out there, right, if you were not aware, they did make major changes to this document in 2021. So if you have one, it's probably a good idea to get it looked at to make sure that it's up to date and it has all the good stuff in it. We typically would advise that we want to have gifting powers on a power of attorney, but again, if the idea is to use every cent for you, maybe we don't want to have the same gifting powers. Again, kind of looking at what the end result of your plan will be, but it's a good thing to consider. You always want to make sure your power of attorney is durable. We want to make sure it can survive your incapacity. That's the main purpose of having it. And some people, again, depending on their circumstances, some, I would say, especially solo people, sometimes really ask for something called a springing power of attorney, which is a document that only takes effect and only can be used if you become incapacitated and a medical professional certifies that you've become incapacitated. We tend to not like that sort of arrangement because unfortunately doctors usually are hesitant to put in writing that someone's incapacitated, but we have had people that really will not feel comfortable with the power of attorney unless it is springing. So again, it is an option. It just typically isn't a great one that we would not recommend, but it can be done if that's where you feel most comfortable.
So one quick anecdote on the power of attorney. It is a dangerous document for solo seniors because there's no one looking over what's going on. We have a case where there was a power of attorney done by an unscrupulous advisor. And that advisor, this gentleman had significant assets. The advisor was looking to get those assets, become the beneficiary or transfer them during lifetime to him or herself. And the power of attorney is a document that can be a tremendous risk for people if not properly done. There is a provision in a power of attorney where you can appoint a monitor. So even though your accountant may not be willing to be your power of attorney, they may look over your financial records and they have the ability to supervise what your agent does under the power of attorney. So consider the monitor provision in the power of attorney. In the case I'm speaking of, the power of attorney was executed and the person tried to get at the assets, but the client had already done a revocable living trust with us. So the assets were not available to anyone other than the trustee that was appointed originally in the revocable trust. So they could not steal from this gentleman. So powers of attorney need to be done very carefully. You can appoint monitors. Very often we appoint co-agents, so they have to act in concert with each other. Security provisions, but the better alternative is a trust. Wills are there if you want to name beneficiaries, appoint executors, but again, we try to plan around the will and into a trust so that you have the ability to do things privately, have control over them, have the ability to have successor trustees with clear direction and instruction, and banks and trust companies will serve in that trust as successor trustees, in addition to potentially professionals and others. But a trust is a much better alternative for someone who is a solo senior. Can't emphasize that enough. One thing I'll throw in with a Medicaid asset protection trust, which you're doing in order to protect assets for long-term care, it is an irrevocable trust. We use something called a limited liability company. So we actually create an LLC, which can be done for asset protection purposes. And we have the LLC inside of the Medicaid Asset Protection Trust with you as the manager. So you can continue to actually manage your own assets if you want to protect them. This may be if you have close nieces and nephews, brothers and sisters. It all depends upon who your beneficiaries are. But if you come to us and say, well, I'm leaving my entire estate to charity, my line is charity begins at home, and that's you. So if you're doing a revocable or a trust, choose the revocable living trust where you are in control, you have access to your assets, they can be used for you throughout your lifetime. And if the charity gets a significant bequest, great. But if you need that money for yourself during your lifetime to support yourself, you don't want to cut off access.
Yeah. Another place where we use that LLC arrangement is sometimes if like you have a big brokerage account, like where you don't want people constantly having to deal with your broker, your investment company. So it gives you the ability to protect your assets, but at the same time, you remain responsible and in control of the portfolio to still do your investment decisions, but it still protects it after the 5 years inside of a Medicaid asset protection trust, where if it's in a revocable trust, you're not worried about that asset protection. You obviously stay in control the whole time.
So that's all we can cover in 30 minutes, and we're at the end of 30 minutes. There's a lot to think about. We hope we covered some of the highlights for you to get you thinking about what you can advise people when they are solo seniors, how they can access the appropriate services of a trust company or a professional advisor, the legal documents like a MOLS that they can put in place that are standalone documents that will carry out their intentions and their wishes. And again, next month, the second Monday, March the 10th, we'll be covering Medicaid home care, legal and financial strategies to qualify. We are going to be covering again the CDPAP update. That is the hot ticket right now. What is going to be the future of CDPAP? We're going to have that on April 14th. May 12th, home care assessments, which have become very daunting, taking several months and delaying and in effect denying care until that process is over. And then in July, nursing home Medicaid. So we'll cover all of these as we go, and we hope you can join us for all of them. We hope you can also join us for the 30th Annual Elder Law Forum, which will be taking place on Thursday, May 15th at the Desmond. It is also available virtually. So it's a full day with legislators, people from the state government, Department of Health, Office for Aging, providers, nursing home, home health care, and a variety of speakers and panels on very important topics. And this year we've actually added a panel on elder abuse. So we're going to look at the issues of elder abuse and how to prevent elder abuse